Righty, so I have 11:30 on my end. So good morning, everyone, and thank you for joining us. My name is Natalie Layton. I'm the Vice President of Membership for the Long Beach Area Chamber of Commerce. Before we get into the webinar, I'd just like to review some housekeeping items very quickly. First, please note that this webinar is being recorded and will be distributed to all attendees, as well as made available on the Chamber's YouTube page. If you have any questions throughout the presentation, please feel free to utilize the chat box or the Q&A function at the bottom of your screen, and Audrianne will answer them as we go. Now, today we are joined by Audrianne Adams Lee, President and Founder of HR Network, Inc. She brings over 30 years of human resources experience and expertise from Fortune 500 high technology and service companies, including Marriott, ADP, Epson, and Western Digital. Audrianne has an extensive background and hands-on experience in the design and implementation of HR leadership and management training programs that help define role clarification and motivate their employees towards increased business performance. HR Network, an HR outsourcing company, was designed to partner with businesses, relieving them of the burden and confusion of complicated and highly regulated human resources systems and employment laws. So thank you so much, Audrianne, for joining us today. And with that, I'll let you take it away.
Okay, thank you, everyone. So we are going to talk about a bunch of different topics today, and we're going to kind of compress them all into different areas. So the first area we're going to talk about are some of the new employment laws that came out. We do this presentation every year, and we typically also do it for the Chamber. Because it is an abbreviated presentation, I don't have all the slides in here, and these aren't all the employment laws that got passed, but it's certainly some of the top ones that we would like employers to be aware of. And some of them are, well, actually, let me share that with you. So we do have a little key here that we use. If it's a California law, you'll see the California symbol up in the right-hand corner. If you see a dollar bill, it means impact on wages. A notice symbol means that there is a notice required for employees. Something posting on the bulletin board means it's a poster you're required to post. The federal DOL symbol, it means it's a federal law. If you see a book, that means a change to your handbook that you need to put in. If you see the clipboard, that means it's a form required. And if you see the people in a training room, it means training is required, although I don't think we had any of those this year. So we're going to go through that pretty quickly this morning, and then we're going to follow it by since the new California paid sick leave, supplemental paid sick leave law just got passed a couple days ago, goes into effect on the 19th in 2 days. We're also going to finish on the back end talking about that as well. Okay, so let's get started. And as I said, as Natalie said, you're welcome to put your Q&A in either the Q&A box or the chat box. She's going to keep an eye on that for us too if you have questions. Sometimes waiting till the end, we've kind of missed that opportunity when you had a question just in that moment about that topic. Okay, let's move on. All right, so I think we went too far. No, I guess not. First of all, California minimum wage increased again. It always does.
I hate to interrupt. It looks like someone did raise their hand. So if you have a question, please feel free to use the chat or the Q&A function. Sorry to interrupt, Audrianne.
No problem. Okay, you see my screen and everything okay? Okay, great. All right, so as you can see here, it's California state minimum wage went up, as well as it's a dollar sign, so it impacts wages. And so this year, if you had 26 or more employees, you're at the cap now, right? $15 an hour. If you have 25 or less employees, your minimum wage went up to $14 an hour. And next year, you will finally hit that $15 cap. One thing I want to point out to employers and companies is that where it ends? Are we done then of minimum wage increases? And the answer is actually no, that doesn't necessarily where it ends. That then they are going to evaluate it on an annual basis based on consumer price index. So minimum wage could increase beyond that in future years, again, based on CPI. Also, something to be aware of is local minimum wage laws. I think I have it on here for because Long Beach certainly has its own minimum wage for hotel employees, and certain counties and cities have minimum wage rules as well. Okay, so minimum wage doesn't just impact your hourly rate of pay, it actually impacts many other things. So when minimum wage changes, other things get impacted by that, and it's really important that employers know that. So obviously it's going to impact the overtime rate. If you have employees on a piece rate, they'll be impacted. If you have employees who are exempt, their exempt salary is going to change as well, minimum exempt salary. I'm going to talk about that in a separate slide. If you do draws against commission, that will have an impact. The notice requirements change. So your California poster that you have to put up with all the legal postings will change because minimum wage changed on that. The other thing that, and I put it up here as a slide, sorry, I think I got something in my eye there, is your wage order. So a lot of employers don't realize that they also have to post their California wage order. There's 17 different California wage orders, and every industry is assigned to one of those 17. So if you aren't sure what your wage order is, you need to find that out. And then you need to download this from the DIR, Department of Industrial Relations, and post this. It's about a 17-page document. What we suggest is you download it, print it out, staple it, put it in one of those plastic sleeves, and attach it to the employee bulletin board. But also, as an employer, you should know what's in your wage order, because it is kind of your Bible for how you pay employees and what the rules are for your industry in the state of California. Okay, if you have tools and equipment, and you have a tool and equipment policy for your employees about providing their own tools, they have to be paid a certain minimum amount. And so that minimum amount will change because minimum wage changed. If you provide meals and lodging, that would be impacted by minimum wage. And then the regular rate calculation for paid sick leave will change as well. And I'm going to talk about that in a separate slide. So you notice up here, we've got, it's a California rule. We have dollar signs, so it impacts wages, and there's also posting requirements. Okay, so LA County and LA City have their own minimum wage, a minimum wage order. Also, I know Long Beach has a minimum wage order. What's kind of important here is, depending on where employees may work, and that where they work is going to be an important phrase. I'll get to that in a minute. You may have to apply different minimum wages to different employees. So if they work in the city of LA, if they work in an unincorporated area of LA County, Malibu, Pasadena, San Diego, Santa Monica, and many other cities in California, you may have a different minimum wage than the state minimum wage. So for example, LA City and LA County, only LA County where there's unincorporated areas, are already at the $15 rate, no matter what size you are. So if you're a small employer with 25 or less, or a nonprofit, you are already at the $15 an hour this year in that locality. Why that's important of where they work is, let's say I have remote workers, and one of my, and this actually happened to me, right? One of my remote workers actually is she's an entry level worker. She's at minimum wage, but she lives in the city of LA. So even though I'm a small employer under 15, my minimum wage is $14 an hour, because she lives and works in the city of LA, I have to pay her $15 an hour, because it's not about where my business is, it's about where she works. And as a remote worker, where they sit every day and work, that's considered their business address. Okay, oh, too fast. All right, so California exempt employees, salaried employees, it's a whole nother presentation I could do on exempt versus non-exempt, but essentially what it is employees who are salaried, we call them exempt, and they are exempt from overtime is what that means. And there's two components of being exempt. One is the duties test, so what job they do, that they qualify under the duties test to be exempt, and the other is the salary basis test, how much you pay them. So to be exempt in 3 of the 5 exemptions, you have 3 of the 5 being executive, professional, and administrative. You have to pay them at least 2 times minimum wage. So obviously if minimum wage went up, so did their exempt salary. So now if I have exempt employees if I have 26 or more employees, my minimum exempt salary is $61,200. If I have 25 or less, my minimum exempt salary is $58,200. Why is that important? Because if I have employees below that minimum salary, as of 1/1, I had to bring them up to that minimum exempt salary in order to keep them exempt. Otherwise, they would no longer qualify. Because remember, they have to meet both qualifications, the duties test and the salary test. Now, the other 2 exemptions are the computer exemption and a sales exemption. They have different salary rules, though. So if you've got somebody under one of those exemptions, those are different rules than this particular slide. Okay, so I want to talk about weighted average overtime and regular rate. And there was a big case decision for California is not required to calculate overtime using weighted average. This is a complicated topic, but I'm seeing many more claims come out of this. Not only because employers don't seem to really understand it well, interestingly, neither do payroll companies. And you know, if you've seen me speak before on HR, you know I always talk about payroll companies are not there to make sure that you are compliant and your payroll is being paid properly. What their job is to write checks, to be a check writer based on the information you provide. It is not to make sure that the information you provide is compliant. A lot of people think that because I do payroll through this payroll company, they would make sure I don't pay improperly. That's not their job, and it's even in their contract in the small print somewhere. So I've seen a lot of payroll companies get this weighted average overtime thing wrong, and the company had no idea. They don't even understand it, and they think, why didn't the payroll company set this up properly? Okay, so let's talk about what weighted average overtime is. First of all, if I pay an employee 2 different rates. So let's say they do, one job at one rate and another job at another rate throughout the week. How do I know where to pay the overtime on? And the answer is you have to pay a weighted average overtime calculation based on both jobs, okay? Or if I pay the employee some type of variable pay, such as commission, then you actually have to pay. If the employee worked overtime, you have to calculate that commission into their average pay to determine overtime pay on the commission as well, okay? This is called weighted average overtime. So in this particular case, which was interesting, the company received these 2 plaintiffs received 2 different rates of pay. And so the company, instead of doing the weighted average method of overtime based on those 2, instead what they did was they paid the overtime on the higher rate of pay. Turns out that the employee benefited from this because they would have been paid less had the company used the weighted average method. But because they didn't use the accepted weighted average method, the plaintiffs brought a claim forward that they didn't get paid properly. And interestingly, the trial court said there's no binding law stating which way you pay the calculated overtime in a dual rate work week, only that you use a method that is most economically beneficial to the group of employees that it affects. So in this case, the company actually prevailed because they ended up paying more than they really would have had they used the weighted average method. So again, this just goes to this whole issue of weighted average overtime.
It looks like we have our first question.
Okay.
So Sylvia raised her hand. It's a question regarding the exempt minimum pay. So Sylvia, I'm going to allow for you to talk and ask your question.
Actually, it was just regarding the calculation. So if it's 2 times the minimum of 15, wouldn't it be 62.4 instead of 61.2?
Oh, you know what? Yes. You know what I'm realizing, as I think I pulled up a slightly older version of this, and this is last year's numbers. You are absolutely right. Thank you, Sylvia, for pointing that out. Wouldn't have even picked up on it because I'm so used to doing this. What I will make sure we do is that we have the right numbers in there, Natalie, before I send it back to you. So when you send it out to folks, they have the right numbers in there.
Great, appreciate it. Thank you both.
But great that you picked up on that, Sylvia. You're absolutely right. So whatever your minimum wage is, it's 2 times minimum wage times 2080 determines what your annual rate would be.
Awesome.
Okay. Okay, so there was SB 331. That was a law about settlement and non-disparagement agreements. And it prohibits the use of non-disclosure agreements to settle any employment or housing related legal claims involving unlawful harassment, discrimination, or retaliation, with certain exceptions. It prohibits employment severance agreements from including these terms as well. What's interesting about this is we've often used severance agreements to when there's a situation where it feels like it potentially could rise to a legal claim. Neither party really wants it to go that direction. And so the company will often offer a severance amount in exchange for release of future claims. And so that's perfectly legal and acceptable as long as both parties agree to it. And those claims that they would then, future claims that they would waive included any type of employment claim, discrimination, retaliation, harassment, etc. Now the law is saying you can no longer include harassment claims. They can no longer just waive their right to file a harassment claim. That no longer can be included in your severance or settlement agreements. And and then the other thing that severance agreements cannot waive, whether you write them in there or not, there's no legal basis for it, is wage and hour claims and workers' comp claims. So now the only thing a severance agreement gets you is a discrimination claim, wrongful termination claim, constructive discharge claim. That's about it, right? So, they don't have the power that they once had. I don't know that they're as valuable as they once were. So, be aware of that. Okay, AB 1003, criminal liability for intentional unpaid wages. So they've actually, the Labor Commissioner has been pushing a while now to really go after employers who don't pay their wages properly, and then also who don't pay judgments against them for unpaid wages. So this now makes this wage theft by an employer a form of grand theft and potentially a felony case in California. I just can't emphasize enough, wage and hour claims, wage and hour is so black and white, right? You either pay people properly or you don't. And the rules are pretty strict in California about all the different ways that you have to pay employees regarding hours worked, meal periods, overtime, if they showed up and got sent home. So on-call pay, reporting time pay, travel time pay. There's just a myriad of things that you have to know to make sure you're paying people properly. So if you aren't sure if you are paying people properly, I really encourage you to contact either a company like ours or whatever HR representative you work with to have your payroll audited and take a look at that. Because now, if you're paying them improperly, especially if it's a large sum of money, you might be found, the employer might be found as a form of grand theft and even a felony charge. Now, obviously, they're going after employers who are intentionally trying to pay people under the table and not pay them correctly. This also arose, I think, out of migrant farm workers who were getting paid under the table less than minimum wage. So they really are going after employers. Last year, they passed a law that said if you had well, first of all, if you get a wage judgment by the DLSE, Department of Labor Standards Enforcement, they will, and you don't pay it that because you want to appeal it, you don't believe you owe it. You now in the state of California have to pay it to the labor commissioner, and they put it in a holding, a trust, until the appeal is done. So you don't even get away there. You have to do that. And if you don't do that, the labor commissioner now has a right to actually put a lien on your personal property, even on your house, because you didn't put the money in the trust. So they're not messing around anymore. You just got to make sure you pay people properly. Okay, garment manufacturing. So this applies directly to the garment manufacturer. We have quite a few of those in the city of LA. But I think it's, even if you aren't in the garment industry, I just think it's an important piece of legislation to kind of see where they're going. It expands joint to any business in the garment industry, supply chains for wage violation, and prohibits the use of piece rates. So the garment industry is traditionally paid piece rate, but again, people don't always pay it correctly because the piece rate has to equal, at the end of the day, at least minimum wage. And sometimes the way piece rates are set up, it doesn't, they're not calculated properly, and they don't end up being at least minimum wage. But what's really interesting about this, and I've seen this actually going for a couple of industries now, is they're saying anybody in the supply chain can have the wage violation. So maybe I am not the actual garment maker, but I provide the material. I'm part of the supply chain, but somewhere along that supply chain, somebody's not paying employees properly. Everybody in the supply chain can now be cited for a wage claim. So that's kind of scary. And it just shows you how far reaching they're kind of going with these wage claims. Warehouse distribution centers and quotas. So this establishes that if you have a warehouse distribution center and you have production quotas, you have to notify your employees of what those quotas are and where they stand on the quota of achieving the quota. So especially if payment is based on meeting those quotas. So if you do have a quota system, you are a warehouse facility and you have a quota system, you have to have that in writing and you have to notify employees. Okay, here's another one very similar to what we just talked about in the garment industry, and that's the port drayage companies, which of course we have some of those in Long Beach. It expands the list of violations that can cause port drayage companies, excuse me, to be placed on the DLSE, Division of Labor Standards Enforcement, and extends joint liability for future violations. So again, if you're part of that supply chain, even though you might not be the one creating or doing the labor violation, if you're part of the supply chain, you might be liable because somebody in your supply chain is not paying employees properly. Okay, public works contractors. I know that we have some of those in certainly in Long Beach, and if you have a public works contract, your contractor or subcontractor is required to furnish their payroll records. It's called a, I forget the name of it, but your payroll every pay period. And if you don't furnish, if your subcontractor or contractor doesn't furnish those payroll records, you can actually be penalized as the contractor, as the public works contractor, and potentially even lose your contract. So you have to make sure that your contractors and subcontractors are furnishing their payroll records as required. Okay, enforcement liens. So again, this is just another level of enforcement that we're seeing from the Labor Commissioner's Office. And they're saying that the Labor Commissioner's Bureau of Field Enforcement, BOFE, didn't even realize, I knew there was a enforcement office, but I didn't know they had their own acronym, BOFE. They are now giving them the same authority to levy liens for citations for wage claims. So not only can the Labor Commissioner's Office do it, the Field Enforcement Office could do it. So let's say, what is the Field Enforcement Office? They might come out and say, we're going to audit your payroll records for the last 3 years. It might show up at your door, and they find that you have wage violations. They might levy a lien on you until a time that those wage violations have been satisfied. Okay, California Family Rights Act. So if you recall last year, California Family Rights Act, or CIFRA, we call it CIFRA for short, changed from being applicable to employers of 50 or more employees to small employers of 5 or more employees. So it kind of went, it almost affects everybody now in California, almost all businesses. So if you didn't add that to your handbook last year, you should have, because you're under that law now. And it includes different family members for which I can take that time off, job protected leave, but they realized they forgot to include parents-in-law. So they just added that on this year. So as of this year, family member, there's a host of other family members already defined. Parents-in-law have been added to it. They also modified their pilot program for mediating disputes. So if you're a small employer from 5 to 49 employees and you're having a dispute over a CIFRA leave, the DFEH has a pilot program to help mediate and work through that issue before you actually get a claim or a fine for not doing it properly. And notice, handbook, right? So you need to update your handbook on this one. Okay, ABC test. So the ABC test is the law where we determine if somebody qualifies as a contractor or not. And the original case where this came about was a company called Dynamex in California. And I forget how long ago this was. It was a year or two ago. And out of this Dynamex case came a law that said, we're now going to follow the ABC test for contractors. The ABC test, just really quickly, A is, I'm not sure quite the order of it, but A is that the contractor doesn't do, or the contractor works primarily on their own with little direction from me. They run their own way of getting the job done. B is they don't really do what I do. And C is escaping me off the top of my head at this moment. I think I might have it on the next page, so we'll see. But essentially, for somebody to qualify as a contractor, I know what C was. C was they're in a business. They're a business of their own, right? So as an example, if I were to hire a recruiter doing as a contractor, I don't really offer recruiting services, but it does kind of fall in the HR field. So I would probably not tell that person, A, how to do their job, just expect that they would get the job done. But B, it's kind of a gray area. Do they do what we do? And C, if they were an individual rather than a company I was hiring, they wouldn't qualify there. All three of those criteria have to be met in order for them to be considered a contractor. So in this case, the ABC test really set the tone for independent contractor issues in 2021. And I will tell you, they are going after these contract cases. So if you are worried at all about the 1099s you have, and if they qualify, you really should look at this and make sure that your contractors are properly classified. Also in April of last year, the Federal Ninth Circuit reversed the district's preliminary injunction against AB 5 as to motor carriers. AB 5 was also a contract issue, a 1099 issue. Also, the state, we all voted for Prop 22 to allow contractors who were like the Ubers and the Grubhubs and those kinds of contractors to be allowed to be contract employees, contracted 1099s. And we all voted for Prop 22, but actually a state court overturned us from it being applied. So it no longer applied. There is an appeal, of course, before the California Supreme Court, but we'll see how that plays out. And then the California legislature also extended some exemptions to some industries who don't have to follow the ABC test, including licensed manicurists and construction, trucking, subcontractors, and newspaper distributors. So there is a general list of people who don't have industries or types of positions that don't have to follow the ABC test, but there's a big but there. Even if they're on that list and they're exempted from the ABC test, then we have to apply what's called the Barillo test, and that is 11 factors that the state of California has put together. It kind of is all the same things we're looking at: who controls the work of the worker, how much do they work on their own, do they have their own equipment, do they make their own hours, do they have their own business, that kind of thing. So again, be very careful if you have 1099s, because they are really taking a look at that. Okay, California DFEH pushes enforcement of the Fair Chance Act. So the Fair Chance Act is, it was a law that was brought into couple years ago, many years ago. I want to say more than 5 now. And we really call it the ban the box law. So what is ban the box? It means I can't ask somebody I'm interviewing or I'm who's part of my interview or recruiting process if they have any felony convictions. And I can't ask that on the application or in the offer, or in the interview. The only time I can ask those questions about their background, their felony convictions or criminal history is after I've made an offer of employment. So we used to call a lot of these activities pre-employment. We're now calling them post-offer, right? Because there's so many things we can't do anymore until an offer's been made. We can't drug test them anymore until an offer's been made. We can't send them for a post-offer physical until an offer's been made. We can't ask about their criminal history until an offer's been made. We can't ask about their salary anymore, their salary history, until an offer's been made. That was a law that came out last year, the year before. So anyway, important, you need to look at your application. You need to determine if I need to change that and make sure anybody who's interviewing is trained on that. Okay, electronic documents. As we're all kind of working, more people are working remotely. The question is, I'm still required to post these documents, but we're always not all in the office anymore. What about those employees? And the state is saying, you still have to physically post those legal posters, your all-in-one poster, or your and your wage order and any other posters you're required to post. But you can also send them to employees who don't have access to the office anymore, who don't regularly come to the office anymore, or are working remotely. As a matter of fact, on some posters, not only should you are required to. So I know, for example, for our clients, we order e-posters for those that no longer have an office location, and the company sends out or makes available on their server the e-poster link so employees have access to that. Okay, new penalties for workplace safety compliance. So Cal OSHA has extended their enforcement, and they're creating 2 categories of violations. So this one's kind of interesting, and this is nothing really to do with COVID, but COVID can be included in this. So let's say I have an issue. I have a safety issue. I've got 3 buildings, and the safety issue, an employee slipped and fell and maybe got hospitalized, so to speak. And so I addressed that issue at that particular building. I addressed that issue at and maybe I've called in the complaint, or called in to OSHA. I have to call it in within 24 hours, and OSHA comes out and visits it. And you say, oh, that's only a problem in this building. And OSHA now has this enterprise-wide violation where they determine, you know what, you have company A, company B, company C, all same ownership. And yeah, you're running them separately, but they're all under the same ownership. And we believe that because the same ownership is running it, therefore, if you had the problem at company A, we expect that problem also is at company B and company C. Therefore, we're going to consider this an enterprise-wide violation. Yikes, right? That sounds kind of scary. Obviously, if that were to happen, you could dispute it, you could appeal it. But the onus would be on you to prove that it was an enterprise-wide violation. And then the other one is an egregious violation. So this is where you either knew or should have known. And because of your action or because of your inaction, something occurred. So even if you didn't know, but you really should have known because you have the proper safety protocols in place, that's not going to be an excuse and it'll be considered an egregious violation. Or I didn't do something I probably should have done, as opposed to doing something I shouldn't have done. Those two are both considered egregious violations. So again, having a safe workplace, having your IIPP, your injury and illness prevention program in place, which is required for all California employers, having your CPP, your COVID prevention program, also required in California, and then doing those safety protocols that you say you do in those documents is really, really important. Okay, OSHA put out new guidelines on incentive programs. So you might have an incentive program because that sounds good. We want people to stay safe. So we're going to incentivize them in some program to stay safe. So every month that there's no accident, we're going to bring in pizza. And every quarter, if we make it to a whole quarter, we're going to do something else. And at the end of the year, we're going to do something really, really big if everyone makes it to the end of the year. The problem is if you make it so attractive that it's almost bad to report an accident because, gosh, I don't want to hinder us all getting this prize or this reward, or I don't want to be the bad guy in this, and so therefore the reward is so substantial, I don't feel good about reporting it. OSHA's saying can't do that, right? You can't have a incentive program that is so substantial that it would prevent people from reporting safe hazards or near misses of accidents, etc. So, you know, I guess it's kind of a gray area of what would be substantial. I don't think a pizza party once a month is substantial. I don't think a $25 or $50 gift card is so substantial, but I had a client who said, we're going to take the employee and 3 family members to Knott's Berry Farm at the end of the year if we have no accidents all year. That could be substantial. I don't, you know, or you're going to take them on a trip or a cruise or whatever. So you have to take a look at that. Okay, CalSavers. So CalSavers is in place. That is California's 401k, public 401k program. If you don't have a 401k program, you have to sign up for CalSavers. This year, by June 30th, employers with 5 to 49 employees have to sign up, right? So your options are A, sign up for CalSavers, or B, implement a 401k plan. And if, by the way, if you have 50 or more employees and you haven't signed up as of last June, 50 to 99, you're already and you don't have a 401k plan, you're already non-compliant and you could be subject to fines and penalties. So please make sure you do that. A couple things we've learned about from CalSavers as we've been helping clients sign up for this. You are required to register for CalSavers if you don't have a 401k plan. And you are required to register your employees, submit your employee information to CalSavers. They will automatically be enrolled in CalSavers unless they opt out. So this is not a passive program, meaning if you have to make sure employees know, hey, you're going to be enrolled and they're going to start payroll deductions as of June 30th unless you actually opt out. Question, Natalie?
Yes, one question is what about a 403B plan?
That's okay. For a nonprofit, that's fine.
Great.
So, okay, so on my next slide, one of our 401k brokers, and you know, you can almost synonymously do 401k with a 403B because that's a 403B is a nonprofit's version of the 401k. But we give you a little chart. You can look at this later. I'm not going to go through all these areas, but the difference between the state-run IRA or a workplace 401k. The state-run IRA is probably going to be cheaper to you, but the benefit to you and employees will probably be a little higher on the 401k side. So you just have to decide what's the right thing for your organization. Okay, IRS mileage rate went up. And I think this is the right amount. But actually, now that we saw that other one was, because I'm worried this might be the old slide. So I know it went up a penny, I believe, from last year. So before I send this out again, I'm going to make sure that that is the right dollar amount, the right number for IRS mileage, because it did go up. When we presented this in December, it had not gone up yet. They hadn't made a decision. They actually didn't announce it until I think the second week of January. So again, just remember when you have employees going, running errands, traveling for business in their car, you have to pay them either the IRS mileage rate, or you have to be able to show the IRS that you covered all their costs, including gas, wear and tear, insurance, etc. Okay, injury and illness prevention program. I talked a little bit about that before. I find a lot of companies don't have this, and it is a requirement by Cal OSHA. If you have an accident at the work, if Cal OSHA shows up at your door and you are 10 employees or more and don't have this written IIPP, it's potentially a $50,000 fine. Now, when would you get a $50,000 fine? You had a really bad workplace accident that OSHA showed up for, and you don't have those safety measures in place, or you had a workplace death. So again, and we just had a workplace death fairly recently, and we had another one last year. Again, OSHA shows up within 48 hours typically after the death of an employee. You do not want to not have your IIPP in place. I hope no one here experiences that. Now, the other thing required is a COVID prevention program. It was something that was put into place, and we thought it was going to be temporary. They have now implemented as a requirement of all employers. And so both of these documents, if you're with State Fund, I believe State Fund even has a template or a model on their website for this. So you can certainly download those. The problem you're going to find is they're complicated documents, so trying to do them on your own might be a little overwhelming. But there are templates out there for you to use. You also can contact us. You can contact your HR provider, or your safety. If you have a safety advisor, they can help you with that too. Okay, so I'm not going to go over this, but these are all what you have to have in your CPP. All these bullet points are parts of your CPP. Remember your posters, those have to be posted for you as well. And one thing I would tell employers that I know a lot of employers don't do is they don't fill in the blanks on their poster. They get it up on the wall, but they don't fill in the blanks. And there's actually, I think, 7 or 8 different places on your poster that you're required to fill in. So let's say the labor board shows up at your door, going to do a payroll audit, and they say, by the way, can I see your posters? And you take them back to the lunchroom, and there's the bulletin board, and you proudly display your posters, but all the blanks are not filled in. $7,000 fine. Okay, it's a $7,000 fine for not having them, and it's a $7,000 fine for not filling it in. So again, very important that you fill in those blanks. I think it's like your payday, your medical provider network under workers' comp, emergency contact information, who to go see if I need a family or pregnancy leave, things like that. Okay, so I'm gonna, the next couple slides are kind of trends for 2022, what's going on, what we can expect. Obviously, we're dealing with the Great Resignation. I've seen people call it the Great Resignation, and now even going to the Great Reshuffle. I literally had an employee quit this morning because he wanted to work from home, and the employer no longer was allowing people to work from home. And more people are saying, well, if I can't work from home, I don't want to work here anymore. So we're trying to tell employers workplace flexibility and life-work balance has become extremely important to employees. And it really may be something you have to embrace if you want to continue keeping your workforce, but it's number one reason why people are quitting. So we're giving you some ideas here of how to try to keep people from exiting your workplace. The first one we call a stay interview. You know, have you ever interviewed people to ask them why they stay there, what it would take for them to stay there, what they like about working for your company? That's really important for you to understand. Next is obviously the one I mentioned, work-life balance and job flexibility. So either remote work or some kind of hybrid schedule. Also really reevaluating who is a qualified candidate. We've got, we had so many people, so many women leave the workforce, and now, you know, if we want to get women back in the workforce, we're going to have to think about, can we offer part-time schedules? Can we offer more flexible schedules? Can we offer, you know, childcare allowances? I mean, and so you really have to think about who your qualified candidate is and what their needs might be. You're probably going to have to increase your salary budgets because prices are going up, salaries are going up. You might consider things like spot bonuses, referral bonuses, sign-on bonuses, retention bonuses. Did you know even Amazon is offering warehouse workers $2,000 sign-on bonuses? I mean, you don't usually see bonuses offered to sign-on bonuses to warehouse workers, and certainly not at that level, but they are. A much broader emphasis on diversity, equity, and inclusion. People really want to see that in their workplace. And you might have to start thinking of some of these out-of-the-box benefits, including tuition reimbursement, health and well-being, and mental health benefits. So those are some ideas. Okay, so what are the major impending issues for 2022? Attracting and retaining is going to be probably the first and foremost for most employers. Remote work, right? What can I offer remote work, and in what way? Pay equity is a big one. So we're seeing pay equity laws both on the federal side and the state side coming through, and they're starting to look at pay inequities. Are you paying any protected group differently than other people in similarly situated situations? So for example, men versus women are doing the same job. People, older workers, people of a certain protected ethnic group. So you really have to take a hard look at your salaries and make sure you don't have any pay inequity going on. Rethinking the annual performance appraisal, especially as the younger generation comes in, this idea that we're going to sit down once a year and talk about my performance. They really want ongoing performance, constant feedback, not this once a year feedback. So you might have to really start looking at how you do performance feedback. Culture and inclusiveness, especially young people really want this. They are, you know, looking at what the culture of the company is, how inclusive are we? How do we include other people within the organization? So, you know, starting to create more culture and inclusive programs. Cybersecurity has become a really big one, right? More and more companies are having issues with cybersecurity, people breaking in. You really, I even have one of our one of our workers' comp and business liability brokers. They have a cyber liability policy now. So that's actually an insurance policy you can get. New federal paid leave laws are coming. So while we've constantly dealt with this on a California basis, we now have federal paid leave laws that are coming as well. Expect those this year. And then again, your agreements. You really need to look at your NDA, your confidentiality, your arbitration, your settlement agreements for some of those reasons we talked about. Okay. I don't think we're going to talk about COVID vaccines. Okay. 2022 handbook changes. So again, if you have a handbook, you need to update your California Family Rights Act, your remote work policy, either your CalSavers or your 401k plan. And then if applicable, if you have a vaccine policy or any change safety protocols because of COVID, you should probably change that. The other option is, instead of putting it in your handbook, make sure your CPP, your COVID prevention program, is updated with those changes. All right, so that's part one. I think we're doing pretty good. So now we're going to proceed over to part two. Let me just bring this over. Natalie, do we have any questions on that before I go into the next slide?
Nope, I think we answered them all as we got them.
Okay, great. All right, let me just get this over. Oh, you know what? I gotta get out of here. Come on. I'm going to stop sharing for just a sec so I can move this on over, and then I'll reshare again.
Great. Yeah, I was just going to say, you might have to do that.
Okay, I'm ready. Let me share again. Okay. All right, so we did want to talk about the COVID sick leave because it just got voted back in. We had been waiting and waiting and waiting for it. We heard it was coming. They kind of let out of the bag early on what it was going to look like, but legislators were kind of still mulling it over and going back and forth on it. And what ended up coming out was slightly different than what we were told early on. So if anybody jumped the gun on that, they might not even be the way it was actually how it was brought forward. Okay, so let's talk about, so the law was SB 114, supplemental paid sick leave. So this is different. It is like we had before, but there are quite a few differences. One, it's for employers with 26 or more employees. So if you're under 20, if you're 25 or less, you don't have to do this. That's great news for you. And I think I understand why they made it for 26 or more, because there is no tax break on this one. You were provided on the previous supplemental paid sick leave. You could actually get an immediate tax break against the wages that you paid out under it. Not in this one. They're not doing that. So I think that's why they applied it to employers with 26 or more employees. It includes employees seeking vaccination appointments and recovering from vaccination side effects. And it goes in, even though it went into, it was announced immediately, it actually goes into effect that you have to start providing this paid sick leave by February 19th. Okay. Now, even as a reminder for small employers, you go, oh, good, I don't have to provide that. You still have to provide exclusion pay no matter what size you are under Cal OSHA regulations. So I'm going to kind of get into the difference between exclusion pay and the California paid sick leave, so you understand the difference and then what order you pay them in. Okay, as I said, there's no direct tax or financial relief for employers who do provide this. They are looking at separate bills, maybe by early summer, of some potential tax relief, but unfortunately, it isn't part of this bill. Okay, so it requires that you provide 2 new banks of leave, up to 80 hours, over and above their California paid sick leave, so their minimum required 3 days of California paid sick leave, any PTO or vacation you offer. So this is over and above that. And it's over and above or in addition to exclusion pay. So if exclusion pay applies, and I'm trying to remember if I have a slide on exclusion pay, I don't remember. If exclusion pay applies, you can't require them to use their supplemental paid sick leave. And exclusion pay, just to remind you, is if an employee is excluded from work because they've been exposed or test positive from somebody at work, then you have to pay them while they are out quarantining. Okay, so if I got exposed to somebody over the weekend at a party I was at, that doesn't fall under exclusion pay. If I got exposed because my coworker got COVID and I now have to quarantine because I was, I was in close contact with my coworker, that would be covered under exclusion pay. If my coworker tested positive and I found out, oh, 3 days later I test positive and I now have to quarantine because I tested positive, and I'm not sure where I got it, but it's automatically assumed if somebody else tested positive in close contact within that period of time, then they got it at work. They would qualify for exclusion pay. Okay, supplemental paid sick leave has to be available for immediate use, and it is retro back to January 1. Now, that one's a little bit of a challenge. How do we retro this back? I'm going to talk about that in a sec. Okay, so what can supplemental paid sick leave be used for? These reasons look familiar. We had reasons that somebody could take off supplemental paid sick leave the first go around. I think they've added a reason here, but here are the 7 reasons. The employee is subject to quarantine or isolation by the health department or the CDC. The good news is we're moving away from that now, for now. Or they've been advised by a healthcare provider to isolate or quarantine, or they are attending an appointment for themselves or a family member to receive a vaccine or vaccine booster, or they're experiencing symptoms or caring for a family member experiencing symptoms related to a COVID-19 vaccine or vaccine booster, or they have symptoms of COVID-19 and they're seeking a medical diagnosis, or they're caring for a family member who's been subject to isolation or quarantine as advised by a healthcare provider, or their child's school is closed or otherwise unavailable due to COVID-19.
It looks like we have a question in regards to exclusion pay. Do I understand correctly, if they have the ability, they can work from home?
Exclusion pay does not apply as long as they can work from home.
Right.
So it's only when they are excluded from essentially working and getting paid.
Got it. Thank you.
Okay, so there are 2 buckets for which employees are entitled to, and you have to think about, so those 80 hours are split up into 2 buckets of 40 hours. The first bucket is for any of the uses we just went over. Any of the uses we just went over. The second bucket is if an employee is only available if an employee or employee's family member for whom they are caring for tests positive for COVID. So first bucket, any of those 7 reasons. Second bucket, I say, show me the test, right? That's how you remember. Show me the test. A positive test, you can start dipping into bucket number 2. Okay, so what is the amount of sick leave that they get? It's up to 80 hours, depending on if they're full-time or part-time. So full-time employees are considered 40 hours a week under this law, even though for a lot of us, we consider full-time now 30 or more, but under this law, 40 hours. Part-time is anyone who works less than 40 hours, but they'd be entitled to whatever their average normal schedule is. So it kind of doesn't matter that they're calling full-time 40, you might call full-time 30, because it is based on their average weekly schedule. And then variable hour employees, so those, like, let's say a restaurant who may work some days one week and other days another week, they're based on an average hour calculation.
Looks like we have another question. What about the home tests that do not state who the test is actually for?
Okay, so this, I think I have it in a slide, but I remember it anyway, so I'm going to talk about it. This law doesn't address home tests. However, Cal OSHA did under their emergency temporary standards and said home tests are not considered valid for employment purposes unless the employer actually watches them being taken and views the test results themselves, or they are proctored by a healthcare professional. So an employee can no longer just take a test and go, look, employer, look at this negative test. It doesn't work that way. They have to be viewed by somebody at the company, or but I mean, you as an employer, you accept it, then it's on you, but you don't have to accept a home test that you did not witness or wasn't proctored by a healthcare professional.
Got it. Makes sense. Thank you.
Okay, so what kind of documentation is needed for supplemental paid sick leave? Well, you're not necessarily required. You're not required to have any documentation in that first bucket, those first 7 reasons. However, you can require you may require proof of a positive test for the second bucket, because remember, the second bucket is only if there's a positive test. For bucket number 2, the employer has no obligation to provide any time in that second bucket if they refuse to provide a copy of their negative test upon your request. So if they can't produce the negative test, you're not required to pay. Additionally, you are allowed to require that they take another test. They say they tested positive, and but in bucket number 1, or somebody else has tested positive, in their family, you can require the employee, if they tested positive at no cost to the employee, meaning you pay for it, that they get tested again on the 5th day after a positive test, which you'd probably be doing anyway, because right now, per the quarantine guidelines, after 5 days, if you want the employee to return to work, you can require them to take another test, which has to be paid for by the employer. Now, paid for by the employer, there's plenty of free tests available out there, so it's not necessarily like you're going to have to pay out of pocket. The employer can also require the employee provide documentation of the family member's test results before paying any additional leave in bucket number 2. Okay, I think this is where I talked about. So request for a positive COVID test is permitted. You are required in that additional bucket to ask, and I'm kind of repeating myself, but I just think this is important so everybody gets it. That the employee or employee's family member tests positive, they can ask for, you may ask for documentation of that positive test in order to dip into that additional or that second bucket. You're allowed to ask them for, after their first test, to take another test in 5 days. This is current guidance under the Department of Public Health and Cal OSHA. And if they are asking for paid time for a vaccination, you can actually limit it to 3 days or 24 hours. So, we don't necessarily, so somebody says, hey, I got vaccinated, but I'm having symptoms. You can limit them to 3 days of supplemental paid sick leave after getting a vaccination or a booster. And if they need additional time off before that, then you can require that they get a healthcare provider to say they needed additional time off if they're still sick. Okay. Oh, here we go. Q&A, are home tests okay? All right, so SB 114 doesn't address home tests, but Cal OSHA temporary standards does. That said, a COVID-19 test now includes specific instructions for workers using a home test with self-read results. The employer or telehealth professional must observe the test results. There's also a federal mandate on this as well. It says the same thing. Okay, so how do I go and calculate the compensation amount of COVID sick leave? Well, you're going to calculate it in the same way you calculate regular paid sick leave. Their regular California paid sick leave at the regular rate of pay. Remember what regular rate means. That's a really important term in California. And that means that it is not just their hourly rate of pay, but it is their either blended rate of pay, or if they get any type of variable pay, such as commissions, things like that, has to be added in to get an average, somewhat of an average rate of pay, or we call the regular rate of pay. So you pay it at the regular rate of pay for the work week in which they use the paid sick time, whether they worked overtime in that work week or not. They also give you an option to do 90-day prior, an average calculation over 90 days. Honestly, I don't know why you do that. I think that will be very, very difficult because you have to do a look back over 90 days. How many hours did they work divided by hours worked? You really are going to have to decide what method you're paying and make sure your payroll company sets this up properly. Now, we know payroll companies are scrambling because this just came out a couple of days ago and it's effective by the 19th. So payroll companies are scrambling to get this set up because it's a different calculation than we used in the last supplemental paid sick leave. I always say people who write these laws have never been business owners, I don't think, or ever worked in business, and they just don't think about the ramifications of implementing it, how it affects businesses, how we actually put things in use, and then we're all kind of scrambling trying to figure that out. Okay, For exempt employees, the supplemental paid sick leave is calculated just like you would do any regular sick leave. You know, it's really might be pay replacement, but they're still going to get the same amount of pay week to week to week. You can limit the amount they get paid though to $511 a day or $5,110 per week for any supplemental paid sick leave. All right, what about these retroactive payments? It says it's effective since 1/1. Well, I've already paid, some people have already taken time off in January and maybe the first 2 weeks of February where they took their own paid sick leave or their own vacation or PTO time. What do I do then? And interestingly enough, you're actually going to have to go back potentially and put that money back in their sick or vacation bank and replace it with the supplemental paid sick leave. So you don't have to go automatically go do that. You have to you can make it upon employee request. So if the employee doesn't request it, you don't have to make any changes. Now, by the way, though, you have to notify them that this is available to them. So I think employees will request it once they understand that it's available to them and they don't have to use their personal sick time or vacation or PTO. So for anybody who took time off between January 1st and February 19th under one of those 7 qualifying reasons, right? Unless they've received compensation over and above what they would get in supplemental sick leave, and they provide you an oral or written request, and you have to provide them a retroactive payment. It needs to be paid on or before the next pay period that they made the request. And it needs to be a separate line item on the paycheck. So again, make sure your payroll provider is setting this up properly, and it would show as a separate line item payment. And then the other thing that has to be on the paycheck, which again is different. So, you know, payroll companies that already set this up one way the last time we had this, now they have to scramble and set it up differently, because now we have to provide them whatever a box on the pay stub of amount of time that they have used. So how much has been used within their bank. And again, that was slightly different than the way we did last time. So hopefully your payroll company is getting that set up. And one of the places you probably should be calling right after you speak with us is the payroll company. Okay. What about employees who quit since 1/1/22 who were absent due to COVID, right? I had employees quit last week that I had already paid sick leave out to or vacation time to because they were out for COVID. The bill doesn't really address that specifically. What they do address is covered employees, right? So a covered employee means an employee is unable to work or telework for an employee due to one of those 7 reasons listed. So we're kind of deciding, we're taking the stance that a covered employee means an active employee, and you're not going to have to go back and do anything with somebody who's already quit. Also, covered family members include child, grandchild, grandparent, parent, sibling, and spouse. Okay. So how does this interact with exclusion pay? Well, if they were out due to a work-related reason, then it's exclusion pay, right? I got COVID at work. I was exposed to someone at COVID at work, and I was excluded from work. That's exclusion pay. You can't require somebody to have to take out of their SPSL bucket if it's exclusion pay reason. If it's not exclusion pay reason, they got exposed outside of work, they are caring for a family member, then it would come out of their SPSL bucket number 1. And absent any clarifying guidance, you can't require them to use their SPSL during their exclusion period. So kind of the hierarchy is, we look at exclusion pay first. Are they excluded because they were exposed or got COVID for work? If yes, exclusion pay. If no, move on to SPSL. Is it one of the 7 reasons? Yes, the first bucket of SPSL pay. They've exhausted that 40 hours, and then they or someone in their family gets COVID, they can show a positive test, then they can dip into the second bucket of 40 hours of SPSL pay. Okay, it does require notification to employees. So employers have to provide them with a model notice. They just published it, I think, yesterday. So the DIR published the notice that you have to provide all employees. You have to post it up on your bulletin board. And if you have employees who don't come to the office or work remotely, you have to send it to them in some type of electronic form. Additionally, don't forget, it has to be listed on their wage statement, or if your payroll company isn't able to do that, then you are required to provide it in a separate document in writing with their paycheck. And even if they've used no hours, you still have to provide that box, and it say 0 hours used, right? So the box is going to say how many hours they have used, where last time around we said how many you have available. This time around we're saying how many of you've used. That's in the box. And you have a very short grace period. This law just came out a couple days ago, and it's already going to be effective by Saturday. Okay, when does it expire? This law is in effect till September 30th. So, knock on wood, I hope we're done with variants of COVID that are going to affect us as far as exclusions and time off and sick leaves, but no guarantee there, right? We know there could be more coming. We hope not. But anyway, this law takes effect until September 30th, and it applies for anyone even up to that day. Meaning if September 29th, somebody comes to me and says, I've already used my first bucket of 40 hours, but I just tested positive for COVID, they can still use whatever time is available in their buckets through September 30th and beyond, provided that they started that leave on September 30th or before. Okay, and the mask mandate ended, as we know, actually it ended yesterday. We thought it ended 2 days ago, but the actual, it ended, the mandate expired on the 15th, meaning you don't have to wear a mask starting on the 16th. But I would also be very careful here. Certain industries still have to wear a mask. Certain localities still have mask requirements. LA County still has a mask requirement. And so just because California dropped their mask mandate, your industry, your business, depending on what your business is and depending where you are, might still have a mask mandate in place. And all employers are still subject to emergency temporary standards, which does require that face coverings in certain situations. So again, that's part of your emergency temporary standards that are outlined in your California Prevention Program, your CPP, which hopefully you have. Okay, keep an eye out for the form. Actually, the form's now out, and maybe I'll make sure to include the link to it when I send this back over to Natalie so that she can, I'll put the link in there so you have that as well. The California Labor Commissioners page, they have a great page on COVID-19 guidance and resource. That's a link there as well. And then be careful because there are legislative and agency web pages in Long Beach, LA City, LA County, and Oakland, where they have their own local supplemental paid sick leave ordinances in effect, and they remain in effect for 2022. So you really need to check those out as well. Okay, I think that's it. We did pretty good, I think.
Yes, we did. You were great on timing. It looks like we had one question that just came in. Any info regarding the daily COVID screening forms that employees needed to complete?
Not required anymore. It's up to you if you want to complete them. You know, I'll just give you a few generals on where we are now, like vaccinations, masks in the workplace, screening forms. You as an employer can choose to have a vaccination policy, or you don't have to. If you do have one, though, you need to make it known to employees, put something in writing. But that, again, would be part of your CPP. If you have a vaccination policy, it could be part of your handbook as well. Up to you if you want to require people to wear masks. Unvaccinated people still have to wear masks. So if you know you have employees who are unvaccinated, they need to be wearing masks in the workplace, right? And you may or may, but you may not know who's unvaccinated because maybe you haven't tracked vaccinations. So you're kind of, as an employer, going to kind of have to decide, how do I move into this next phase between masks, vaccination, paid time off, screenings, etc.
Awesome. And it looks like there's one other question that came in. So are staff capped at 40 hours per bucket? What if they test positive numerous times between February 19th and September?
Then they would be able to go into bucket number 2 for another 40 hours, and it's capped at 80. So if you test positive and have to quarantine 5 times between now and September 30th, you're capped at 80. After that, we're back to it's either unpaid, use your personal paid sick leave, or vacation leave.
Got it. Great. It looks like that's all of the questions that we had. So I just want to thank everyone who logged on, and thank you so much, Audrianne. And I apologize if it's a little noisy. We have the full team back in person, and we're getting back to it, and we're very excited to be all together. But I will, as Audrianne said, I will definitely send this out to all of our attendees. And as well as a recording will be made again available on our YouTube page, and I will send a link to that as well for anyone who wants to listen back to it.
Okay, and I'll get that updated PowerPoint over to you in a little bit.
Not
Thanks,
a problem.
everyone.
Thank you so much. Thank you, Audrianne.
Bye-bye.